If you're going through a divorce and what would be considered a high net worth divorce, which is a divorce where the estate is worth greater than $2 million, there are additional challenges that you may face that somebody going through a regular divorce wouldn't necessarily face. One of the reasons that you may face additional challenges in a high net worth divorce is just because of the value of the estate. The stakes are so much higher. That if we were dealing with a divorce where the estate was worth $100,000 and we're talking about one party getting 51% versus getting 50%, well, that 1% was worth $1,000. Parties are not going to be willing to fight as much and expend legal fees over insignificant sums of money. However, that 1%, when you're talking about a $10 million estate, is now $100,000. People are going to fight for that. And because they're going to fight for every little thing, every detail matters so much more. Additionally, with high net worth divorces, you're more likely often to find that there are business owners. And because of that, there's going to be additional litigation that sometimes comes with that. With a high net worth divorce, a lot of times we'll run across more unique properties that have to be divided or valued. Typically in a divorce, the typical assets that you're going to see are the parties' homes, the money in the bank account, the vehicles, and a retirement account. However, in a high net worth divorce, there are many other assets that you may come across, like artwork or a business, intellectual property. All of these assets are very complicated as to how we determine the value in dividing the value of the estate. And it's very important that you have an attorney who has the knowledge as to how to properly value assets like that to get you through this process. Now, in a high net worth divorce, child support is still often going to be capped at the percentage that somebody's supposed to pay is still going to be the same. For one kid, it's 20%. For two kids, it's 25%. Three kids, 30%, so on and so forth. However, with a significant income earner, that child support is usually going to be capped at their net worth being $9,200. So it's 20% of the first $9,200 somebody earns a month, or 25% if they had two kids. Now, it is possible to get the court to go outside of the child support guideline if somebody is earning way outside of the guidelines, or if the children's needs are greater. So if you have a child with special needs, or you have just somebody where their earnings are in the seven figures and the child is used to going to a private school, or the child is used to a certain lifestyle, you can, in those circumstances, get a court to ignore the guidelines and go above the guidelines. If we're looking at how to examine spousal support in a high net worth case, first of all, we need to distinguish between temporary spousal support and final spousal support. For temporary spousal support, the court is absolutely going to make sure that the parties are taken care of. And if you have somebody who is earning $25,000, $30,000 or more a month, and the other spouse isn't earning any money, all that money that the income earning spouse is earning is community property. So as the court sees it, the other spouse is going to have a right to some of that money as they need to make sure that their bills are being paid. The court is going to look and determine how much are the bills of each party? What are their necessary expenses? And then what are the abilities of each party to pay those bills? Nobody's going to get a free ride here. People are expected to work and earn their own income. However, the court is absolutely going to consider the parties' income earning ability and the disparity that may exist when ascertaining whether or not to order temporary spousal support. As to whether or not to order final spousal support, the court needs to first determine that there is not sufficient community property to order spousal support, because what the courts typically would rather do than order spousal support on a final basis is to award a disproportionate share of the community estate. So the court may give one spouse 60% and the other 40% to make sure that the spouse that isn't earning as much money is able to use that difference to help get them started in a transition towards a new life where they're no longer going to be living with the income-producing spouse. It is still possible to get spousal support on a final basis. However, it is more difficult when there are significant assets available. If you're a high net worth individual contemplating going through divorce or going through a divorce, and you have any questions about this or any other legal matters, give us a call at the Bayley Law Firm for a consultation today.